What's up, everybody? Welcome back to the channel, or if it's the first time here, welcome to the channel. My name is Andrew, and today we're talking about the current trademark war that's going on for the Conjuring House. I went and I've talked to Jason Hawes about it. I've also talked to Elton Castee, and I've got his take on the whole thing. I have thoughts on it that I wrote into the script, so you guys are going to hear about that. But first, since this is a re-upload, this is a re-record rather, and then I'm going to have to re-edit and re-upload it. There was some audio-visual bugs on the first one. Unfortunately, it's just the way it is. I couldn't get rid of them because they were just baked in. The camera with the autofocus, it turned itself back on and stuff like that, and it was just kind of pixelated a little bit. And there was an audio bug where, for some reason, it was doubling my voice on YouTube. I don't know if that was an actual YouTube bug or if that was in the video itself. I just thought it safer to go ahead, re-record, re-edit, and we'll go again. So without any further ado, crack you open something to drink, and let's get into it. Monster Nitro, by the way. Tastes just like orange juice. All right. War for the Conjuring House. Trademark war. For years, the Conjuring House has been one of the most famous paranormal locations in the world. Millions of people know the name. Investigators have traveled there. Tourists have paid to visit. And countless YouTube videos, documentaries, television shows, and news reports have used the same phrase, the Conjuring House. I told you that today there is an active legal battle over who owns that name. Not the house, not the land, not the mortgage, but the name, the Conjuring House. And according to the public trademark filings, court records, corporate registrations, and domain records, the fight has become one of the strangest legal battles the paranormal world has ever seen. And at the center of the dispute is a federal trademark application filed in October 2025, an application that claims commercial use of the phrase Conjuring House dating back to at least October 1st, 2015. But there's just one problem. According to the historical timeline of the property, the house wasn't operating ghost tours in 2015. It wasn't operating as a museum. It wasn't operating as an overnight paranormal experience. It wasn't even operating as a public attraction at all. Instead, it was a private residence. So, where did those claimed trademark rights come from? That's the question at the center of this story. And to answer it, we'll have to go back to the beginning. Act 1. The Icon. Long before the lawsuits, the LLCs, the trademark filings, and the court battles, there was simply an old farmhouse in Burrillville, Rhode Island. Historically known as the Arnold Estate, the property has existed for centuries. For decades, it was a simple private home. That changed in 2013. When Warner Bros. Released The Conjuring House, the farmhouse became internationally famous overnight. Whether you believe the ghosts or not, the impact of the film is impossible to deny. The movie became a massive success. The location became a destination. And perhaps most importantly, the public began referring to the property by a new name, the Conjuring House. This wasn't the result of a trademark filing. It wasn't the end result of a marketing campaign. It was simply the name people adopted. News articles used it, television shows used it, paranormal investigators used it, fans used it. The phrase became synonymous with the property itself. At the time, however, the owners were not operating a paranormal attraction. Norma Sutcliffe and Gerald Helfrich lived in the home as a private residence. In fact, the attention created serious problems. According to public reporting, the owners faced trespassing issues and unwanted visitors as curiosity surrounding the property exploded following the film's release. Despite the property's growing fame, there were no commercial ghost tours operating there in 2013. No museum, no public overnight investigations, no paranormal businesses. Just a private home that had suddenly become one of the most recognizable haunted locations in America. And that fact becomes critically important later, because while the public may have known the property as the Conjuring House, the question isn't whether the name existed, The question is, who was using it commercially? And that's where our story begins to get complicated. Act 2, the land grab. To understand how a trademark dispute emerged around the Conjuring House, we first need to understand what was happening with the property itself. In 2019, paranormal investigators Corey and Jennifer Heinzen purchased a home and transformed it into a commercial paranormal destination. For the first time, visitors could book investigations. Tours became available. The farmhouse had evolved from a private residence into a business, and importantly, it operated publicly under the name the people had already come to know, the Conjuring House. 3 years later, in 2022, the property had changed hands again. Boston real estate developer Jacqueline Nunez acquired the property through her company, Balefire LLC. The operation expanded. Events increased. The property's visibility continued to grow, but behind the scenes, financially, problems were beginning to emerge. By 2025, those problems had become impossible to ignore. The property was facing foreclosure. A public auction was scheduled, and that's when a new player entered the story. On October 8, 2025, a Rhode Island company called Summit & Stone LLC purchased the property's underlying mortgage note. The company was connected to YouTube personality Elton Castee. At first glance, many people assumed this meant that Elton had purchased the house. But that's not what happened. He purchased the debt, and in real estate law, debt and ownership are not the same thing. One controls the loan, and the other controls the deed. This distinction would soon become the center of a growing legal war, because while Summit & Stone was acquiring the mortgage, another transaction was taking place. Ghost Hunters founder Jason Hawes was pursuing a purchase agreement directly tied to ownership of the property itself. The result? Two separate interests now existed. One side held the debt. The other side claimed ownership through deed transaction. And then, only days later, something else appeared. A federal trademark application. Act 3, the claim. On October 17, 2025, an application was submitted to the United States Patent and Trademark Office. The mark being claimed was simple: Conjuring House, because you can't trademark the word "the." The applicant was listed as Haunted Homes LLC. The filing sought protection for two categories of service: Class 041, ghost tours, historical site tours, museum services, occult exhibitions, and Class 043, temporary accommodations, hotel-style lodging. The application itself wasn't unusual. Businesses file trademarks every day. What made this filing different were the dates. According to the application, the mark had first been used as early as October 1st, 2013. The filing further claimed first use in commerce as early as October 1st, 2015. Those dates would become the foundation of everything that followed, because trademark priority is often based on who used a mark first, not who filed it, not who bought a property first, but who used it first. The filing was submitted under Section 1A, meaning the applicant was declaring that the mark was already being used in commerce. The application was signed and submitted under oath, and shortly after publication, it drew immediate attention. Act 4, the evidence. When filing a trademark application based on active commercial use, applicants must provide evidence showing how the mark is being used in commerce. This evidence is called a specimen, and in this case, the specimen would become one of the most controversial parts of the entire filing. According to the application, the supporting specimen was not a ticketing page operated by Haunted Homes LLC. It was not a booking page for tours operated by Haunted Homes LLC, and it was not a website owned by Haunted Homes LLC. Instead, the filing references a page hosted by bostonghosts.com. The application describing this page as an example of use of the mark in commerce. That immediately raised questions from opponents of the filing. Why? Because trademark law generally requires applicants to demonstrate their use of the mark in commerce, not simply the existence of a mark on a third-party website. The filing also contains a federal declaration signed under penalty of law, affirming that the facts contained within the application are believed to be accurate. At this point, the dispute was no longer about whether the filing existed, because it clearly did. The question became whether the evidence submitted actually supported the claims being made. And that brings us to the timeline. Act 5. The timeline. Remember those dates, October 1st, 2013 and October 1st, 2015, because everything hinges on them. Let's compare the filings to the historical record. The application claims first commercial use by October 2015. So, what was happening at the property in October 2015? The answer appears straightforward. The home was owned by Norma Sutcliffe and Gerald Helfrich. It functioned as a private residence. The property was not operating public ghost tours. It was not functioning as a museum. It was not operating overnight paranormal experiences. And it was not operating as a commercial haunted attraction. At that time, the farmhouse was still years away from becoming a paranormal tourism destination. The Heinzens would not purchase the property until 2019. The commercial attraction most people know today did not yet exist, which creates an obvious question. If commercial ghost services were being offered under the name Conjuring House in 2015, who was offering them? Where were the tours? And what were the ticket sales? Lastly, where was the business's operation? Perhaps most importantly, how could a company formed in 2025 claim commercial use dating back a full decade earlier? Those questions now sit at the center of the trademark dispute, and they would soon become formal legal arguments. Act 5.5, Elton responds. At this point, I wanted to make sure I wasn't simply telling one side of the story. Before recording this video, I reached out directly to Elton Castee and offered him an opportunity to respond to the questions surrounding the trademark application. After some initial discussion, Elton provided a response explaining his position regarding the filing. In his response, Elton argued that the formation date of Haunted Homes LLC is not relevant to the trademark priority. He compared the situation to a company creating a new corporate entity while continuing to use intellectual property that existed beforehand. He also argued that the Conjuring House became a widely recognized commercial name following the release of the 2013 film, and that the trademark filing itself was handled by a trademark attorney. The response raises an important distinction, though. The question isn't whether the phrase, "The Conjuring House," existed in 2013, because it clearly did. The question isn't whether the public used the phrase, because they clearly did. News outlets used it. Television shows used it. Paranormal investigators have used it. And fans have used it. The phrase had unquestionably entered the public consciousness, but that's not the question sitting before the Trademark Trial and Appeal Board. The question is much narrower. Who was using the mark in commerce for the specific services listed in the application? As of this publication of this video, I have not located public records showing who, if anyone, was providing those services listed in the Conjuring House mark in 2015. The question now sits at the heart of the trademark dispute, and it's one of the key reasons that the application is currently being challenged, because ultimately, this isn't a debate over whether people knew the name. It's a debate over who can legally claim commercial rights to it. Act 6, the opposition. As the filing moved through the federal trademark process, opposition arrived. Jason Hawes formally challenged the application. This dispute moved before the Trademark Trial and Appeal Board. The arguments raised in opposition focus heavily on the historical timeline. The opposition argues that the claim dates of commercial use are unsupported by the historical record. The challenge further argues that the property's commercial operation did not begin until years later under entirely different ownership. The opposition also points to the fact that the phrase "The Conjuring House" had become publicly associated with the property long before the trademark filing was submitted. The trademark application remains contested. No final determination has been issued. But the filing is no longer proceeding unchallenged. The battle over ownership of the name had officially begun. While the public waits for video drops and online statements, the federal government just shifted this battle into high gear. I spoke directly with Jason Hawes, who confirmed that the Trademark Trial and Appeal Board has officially instituted his legal challenge under opposition number 91307-969. The application is no longer just being questioned by critics. It's now on an active formal case before the Board of Education. The federal government has now issued a directive forcing Haunted Homes LLC to step forward and legally answer these timeline claims under oath. If you look closely at the public records, you can see the literal gears of the trademark office turning. When I asked Jason for permission to show the documents, he gave the green light, noting that the historical Arnold estate is a matter of public record. With formal trial schedule now active at the federal level, the corporate battle lines are officially drawn. One side leaves the technicalities to the professionals, while the other side uses raw historical data to dismantle the application entirely. At first glance, the story appears to be about a haunted house, but look closer and you'll find something very different. A fight over intellectual property, a fight over historical use, a fight over branding, and ultimately, a fight over who controls one of the most recognizable names in paranormal culture. The courts will continue to address questions involving ownership of the property. The Trademark Board will address questions involving ownership of the mark. And until those battles are resolved, one question remains unanswered. Who owns the Conjuring House? The house itself may eventually have a clear owner, but the name? That fight is still ongoing. If new filings, court orders, or trademark decisions emerge, we will continue to follow this story. Until then, the documents remain public, the records remain available, and the timeline speaks for itself. If you enjoyed this investigation, be sure to like the video, subscribe to the channel, and let me know your thoughts in the comments below. And as a result, review the documents, follow the evidence, and draw your own conclusions. Anyways, guys, thank you so much for watching. If you want to support the channel, there's a merch bar down below. You can also hit up the PayPal link and buy me an energy drink if you want. You don't have to. But I do appreciate you guys for checking this video out. This is the first video I've put out in months. And I was kind of eager to jump into this. So also new studio, new look coming about. So I'm getting all this built out. It's cool. Obviously something has changed with my voice too, to where now I'm sitting way lower than I was. So whatever that's about, I don't know, but I'm kind of digging it. I'm liking how it's sounding right now. It sounds a little bit like Kratos. Boy. Anyways, I'm going to get out of here, and I will catch you guys next time. Peace out.